It was so funny at work. Because everybody was freaking out. Everybody was, operating like fully their calls, all the parents. It's so funny. Here. Yeah. It's great. Exactly. Yeah. They didn't score last night.
What's wrong with my phone? I can't access my phone. What the heck? That's really bizarre.
Hey guys,
Hi.
Martin's running a little late, so we'll probably start in like 5-10 minutes.
Oh, cool. We're all late today.
Yeah.
Weird.
9:30. 9:30. Okay.
9:30. Wow.
He just got in. He just got in.
Oh, cool. Hold on. My phone is not working. Can you guys hear me?
Yeah.
Okay.
How you doing, sir?
Hello. I'm gonna go get another chocolate pellet. That was exciting.
Today is like the worst day to run any errand. Everywhere is like traffic. So it's
Yeah,
like-
how is it down there? Bad?
Over here, how is
Pretty
about,
flooded.
yeah.
Well, actually, I wouldn't know. I haven't driven out. Just from what everyone said.
So many roads closed, like major roads get through places. And then people that use those major ones, they have to take the other one, so it's like double.
Oh, God.
Like,
Yeah.
oh, it's great.
It's crazy. It stopped raining here.
And
So.
Where are you?
Carlsbad.
oh,
How was the rain there?
It stopped, but it was horrible this morning. It took me almost 4 hours to get here.
How do you like Carlsbad?
I like it. I don't like driving there, but I like Carlsbad.
I don't know. A friend of ours is thinking of moving there, so
Really? Oh, it's nice.
she didn't like the price of real estate.
Right.
Okay. Oh. There's a couple of stoplights that appeared that were out, it looked like they were out at major intersections on 111. And Fred Waring at Cook, I mean, traffic was like backed up for looked like a mile. So if you're going back that way, anybody, don't. Well, did you find this chapter appealing?
Oh.
This is 4 pages.
Okay.
Does that break everybody's heart? Okay, so I had left early tonight, and I was gonna put a bunch of stuff on the whiteboard, but no. So, who can appeal?
Someone who has gotten a final order.
That's good. That's good. I like that. Only an aggrieved or losing party may appeal. And you can only file an appeal if you were a party to a lawsuit who is not settled. What does that mean?
Once you settle, you waive your right to appeal.
That's right. So what's an aggrieved or losing party? You look for adversity. Where a party prevails on one of several claims or defenses but loses on others. An appeal lies. A rejected claim or defense would have entitled the appealing party to more or different relief. Okay, that provides adversity. That noise.
I'm sorry.
Okay, thank you. Oh, the hell with adversity. Let's forget adversity. That's just making it more confusing. What's an aggrieved or losing party? Let's go through it again. party prevails on one or several claims or defenses but loses on others, an appeal lies if the rejected claim or defense would have entitled the appealing party to more or different relief. So, Clara, what is that? Sounds like a call.
My phone is not working. I don't know why I can't call anybody. So I access the audio through my computer, and maybe it's something on my computer or something.
You can't mute it?
I don't know how to mute well, yeah, I can mute my computer, but I think did I mute you, right?
We won't ask you until we get to you. Just turn that damn thing
Yeah, then I
off.
can't hear you. I'll turn it down.
Wait a minute.
Well, no, you should be able to hit mute on the Zoom.
Oh, you hit mute on Zoom? Okay. Oh, okay, I see.
Mute button, yeah.
Thank you.
Yep,
Yeah.
you're
All
good.
right, Clara. Tell us about, so let's just step back a minute. So the issue here is if you win on one part and you lose on another part, are you an aggrieved party? Okay? Clara, tell us about Aetna versus Cunningham.
Can you hear me?
Yeah, now we can.
Okay. So here we have an owner or developer that, okay, wait a minute. Okay, in Cunningham, the contractor failed to complete the project, and Aetna, the insurer, stepped in. So let me back up a little bit. So this is an owner or developer that requires that its main contractor take out an insurance policy to cover the possibility that the contractor will not be able to complete the project. So
And
Aetna's the insurer, right? So in this one, Cunningham is a contractor and he failed to complete the project, and Aetna, the insurer, stepped in. So the project was completed with Aetna's money, and then Aetna tried to recover $32,000 from the contractor. So at trial, Aetna presented two theories for recovery. One was recovery permitted per the terms of the contract, and second, the contractor had committed fraud in applying for the policy, and Aetna's loss was traceable to that fraud. So the district court found that Aetna on the contract claim, but ruled that the contractor had not committed fraud. So they got the first, but not the second. They got the recovery, but not that the contractor had committed fraud. So both Aetna and the contractor appealed.
Okay. So Aetna's appealing on the
fraud.
fraud part.
Right. So they won on one part, but not on the other part.
Right.
So
What's the issue?
I have as the issue as an issue on appeal was which party could raise which contentions of error on appeal.
Not really, but go ahead.
Okay.
What rule did you get?
The rule I have, I got on page 673 that it was kind of hard to find, but I got that. It would be premature for us to pass upon the effect of bankruptcy on a judgment on either claim.
No.
No?
No, not even close. Okay. The issue is who can appeal, or, as I previously said, where a party prevails on one claim or a number of claims and loses on others, can they appeal on the claims that they lost? Okay? And the court held that since Aetna was denied judgment on the fraud count, it is an aggrieved party, it lost on appeal. And it went on to say, when the denial of any one claim results in the plaintiff not getting the relief to which it claims to be entitled, whether in the amount or the quality of the judgment, it has a right to be heard on appeal. And so the important part, the rule that you want to remember is when the denial of any one claim results in a party not getting the relief to which it claims to be entitled, it has a right to be heard on appeal. Okay? So let's look at note 1A through C on page 673, Clara. You're still on the hook. So read
Okay.
out 1A through C.
So 1A, applying the principle of,
First, you can read 1.
the insurer won on the contract theory but lost on the fraud theory. May the insurer appeal? So A is applying the principle of the adverse judgment. The answer would be no. The insurer was seeking only compensatory damages, so the amount of the recovery on the contract claim was identical to that under the fraud claim. Winning on the fraud count would therefore not have increased the judgment.
B.
So B, nevertheless, the count allows the insurer to appeal the unsuccessful fraud claim. Why? Key to the answer is the fact that fraud liabilities may not be discharged in bankruptcy, but contract liabilities will be. C, how could the plaintiff have framed the prayer for damages so as to assure appealability if the plaintiff lost on the fraud count?
Okay, so let's go back to B for a minute because that's accurate. If fraud cannot be discharged in bankruptcy, whereas the contract claim can be. So that by losing on the fraud count, if the defendant was to file for bankruptcy, they would be SOL. Okay? Therefore, the fraud count did give them a measure of remedy beyond the contract. Okay? This is pretty sophisticated. The court was looking ahead to the bankruptcy. The court said the law is fashioned to work substantial justice in real transactions. That's what they mean. With respect to how would the plaintiff frame the prayer for damage so as to assure appealability, so they don't have to talk about bankruptcy? What do you think? It's fraud. What can you plead in fraud that you can't plead in contract?
Punitive damages?
Yeah. So if you plead punitive damages, it's clear. Okay? So you're getting a hang of it. All right? So the test is if by losing a cause of action or a claim, you're in some way out a remedy that you don't have on the claims that you won, then you can appeal. That's an adverse judgment. You're an aggrieved party, okay? Okay. Rule 46 says that a party must present the contentions that they may want to appeal below. I'm sorry, a party must present the contentions below in the trial court on which it wants a ruling. If those contentions are not raised at trial, then they're lost. Get it? So even if you think that if it's an important issue in the case, even if you think you're going to lose it, you have to raise it during the trial phase. If you don't raise it, it's gone. So the question is a 12B6 motion enough? What do you think? The motion to dismiss for failure to state a claim. You think that's enough? You raise it, you file a 12B6 motion, but you don't raise that issue at trial. After the plaintiff rests his case or her case, you're the defendant, and you don't make a motion to dismiss for failure to state a claim. What do you think?
Then you waive it.
It's waived. Okay? You can appeal other issues that it's against a verdict against you is contrary to the law, contrary to the great weight of evidence, but that's not failure to state a claim. You understand the difference? Okay, so 12B6 motion, 12B6 motion is not a grounds for filing a 12B6 motion and losing it is not a basis for appeal. Okay? Remember that. It could be tricky on those multiple choice questions. You can have a question like so-and-so filed a 12B6 motion and they lost a trial and they appeal for failure to state a claim. Pretty straightforward, and the answer is no. That's in note 1A on pages 675 through 676. The case is Mims versus Central Manufacturers Mutual Insurance. You guys should all read that note. Note 1A, pages 675 through 676. Okay, what's a final judgment? Isabel.
A final judgment is one where the court no longer has to do anything except execute.
Yep. Well, got to get this completely right because it's pretty easy. So remember this. Don't be in the outline I give you, but one which ends the litigation on the merits. On the merits is important. Has to end the litigation on the merits and leaves nothing to do but execute the judgment. So you got to get, that's one sentence. Just put that in there and you're home free. Okay? Except that's called the final judgment rule. If the final judgment rule is, if the judgment is not final, the court lacks subject matter jurisdiction. That's the rest of it, okay? That's on page 688. All right. So, Isabel, why don't you tell us about Liberty Mutual versus Wetzel?
Okay, so Wetzel sued Liberty Mutual in federal district court alleging that Liberty Mutual's employee insurance benefits and maternity leave provisions violated Title VII of the Civil Rights Act of 1964. Wetzel brought a declaratory judgment and injunction and damages. The district court granted Wetzel a partial summary judgment on the issue of liability, holding that the policies did indeed violate Title VII. However, the judgment did not provide any of the relief sought by Wetzel. The respondent's complaint alleged,
Wait, go back and say that again.
the judgment did not provide any of the relief sought by Wetzel.
Yes. Okay.
The respondent's complaint had the following, she, prayed for a judgment against petitioner embodying the following relief. It was A, requiring that defendants establish discriminatory hiring, payment, opportunity, and promotional plans and programs. B, enjoining the continuance by defendant of the illegal acts and practices alleged herein. C, requiring that defendants pay over to plaintiffs and to members of the class the damages sustained by plaintiffs and the members of the class by reason of defendants' illegal acts and practices, included adjusted back pay with interest and an additional equal amount as liquidated damages and exemplary damages. D, requiring that defendant pay to plaintiffs and to the members of the class the cost of the suit and reasonable attorney's fees with interest, and E, such other further relief as the court deems appropriate. So Liberty Mutual appealed the grant of partial summary judgment. The Circuit Court of Appeals.
Whoa.
Yeah.
Okay. They were seeking, amongst other things,
Yes.
they were seeking an injunction, right?
Yes.
Okay.
So the Third Circuit Court.
Wait. Hold it.
Okay.
So plaintiffs were seeking an injunction, right? And Liberty Mutual appealed the denial of its motion for partial summary judgment,
Yes.
correct?
Correct.
What did the district court do upon Liberty Mutual appealing with respect to the injunction?
They issued partial summary judgment, right?
Yeah, partial summary judgment says they're liable.
Mhm.
And it said it was going to grant an injunction to enjoin Liberty Mutual's discriminatory practices.
Yeah, and then they denied it. They denied whatever.
No, I said they were gonna grant the injunction, then Liberty Mutual appealed, and the court did something with respect to the injunction. Do you have that?
Yeah, I remember the plaintiffs were to submit forms of injunction. Is it what they wrote in regards to the 20th of February?
The court
Where they
stayed the
where they stated
injunction.
that?
Do you understand what staying the injunction means?
That they asked for it to stay in place?
If you stay the injunction, that means the court didn't actually go forward with the injunction. Stay means it's like suspended, okay? So when it stays, then when the court stays something, it's holding off while it's on appeal, okay? So while it was on appeal, Liberty Mutual was not enjoined from whatever its alleged practices were. Okay, get it?
Yeah.
Okay, so what did the circuit court do?
They held that it had jurisdiction and affirmed the judgment. The Supreme Court granted certiorari, and so the issue I have is, does the Court of Appeals have jurisdiction to review the granting of partial summary judgment?
That's good. First of all, you know what certiorari is?
Just that they, that they can review it.
Yeah. Well, no, it's a writ of certiorari is something you file with the Supreme Court of the United States, asking the Supreme Court to hear the case. Okay, and if the court decides to hear it, it grants the motion. Okay.
Okay.
It takes about 5% of the cases that are filed with it.
Oh.
And in any one year, it used to be 200 cases a year, and now it's down to less than 100. It's something around 95 cases. Okay, so if they divvy it up amongst 9 justices to write opinions, that's 10 apiece. Got it? Okay.
So my rule I have is a court of appeals does not have jurisdiction to review the granting of partial summary judgment. The such orders are interlocutory in nature and thus are not final judgments within the meaning of 28 U.S. Code, section 1291. They said that the district court granted no relief whatsoever when it was decided on the issue of Liberty Mutual's liability. So, Rule 54B does not apply to cases like this, which are actions on a single claim, and the requirements of section 1292B were not satisfied. They further said that, if they were to allow the courts of appeals to exercise jurisdiction over these types of cases, they would condone the procedure, whereby any district court could render an interlocutory decision on liability, which would be immediately appealable. So they said, although Congress has provided for exceptions to the final judgment rule, none of those were applicable to this case. So they vacated and remanded with instructions to dismiss defendant's appeal.
Okay, that's pretty good. Okay. You can sit in. I'm gonna add to that. Okay. Rehnquist, who was, I guess he wasn't Chief Justice at the time, but anyway, I don't know. He became Chief Justice if he wasn't when this was written. Yeah, Mr. Justice Rehnquist. So he wasn't Chief Justice yet. He wrote that an order of partial summary judgment on liability, which leaves unresolved the determination on damages or relief, is not a final judgment. Okay, this case involves the final judgment rule. And what is that final judgment?
A
Okay.
decision that ends the litigation on the merits and there's nothing to do but execute the judgment.
That's the overriding definition.
Yes.
But what happens in a case like this, where there's a partial summary judgment, okay, and the court renders partial summary judgment, is that partial summary judgment, it is a judgment, okay, appealable. And you go back to, does it leave anything left but the execution of the judgment?
No, they said there wasn't.
Huh?
It wasn't appealable because they were interlocutory in nature.
What does that mean?
That it's still,
What does interlocutory mean?
doesn't that mean that it's like in the pre-trial stages?
What does interlocutory mean? Anybody have?
I looked it up yesterday too and I forget.
interlocutory appeal? An interlocutory appeal is an appeal of a ruling by a trial court that is made before the trial itself is concluded. It asks an appellate court to review an aspect of the case before the trial is concluded.
Right, and that's what the next case is about.
That's
and how
interlocutory.
That's not allowable, right?
Well, there are some interlocutory appeals that are allowable. We'll get there in a minute. Okay? But the reason this one wasn't is because it left the granting of partial summary judgment on liability in this case left unresolved a determination on damages or relief. So therefore it wasn't final. Okay? And the court went on to say injunctive relief, if stayed, is not a final judgment. In other words, had the court granted the injunction and not stayed it and said, you got to do this, then that would be an appealable order, even before trial. Okay? So damages are still left up in the air, but they can file an interlocutory appeal to review a granted injunction. Get it? Okay. And then the court went on, as you said, it said the plaintiffs received none of the relief it sought. Quote, they sought an injunction, did not get one. It was stayed. Okay? They requested damages, but they were not awarded. They requested attorney's fees, but received none. Okay? So there's nothing yet to appeal. So you got to go to trial. Now, here's some examples of rulings that are not final. Most pretrial motions that do not resolve the case. So that would be most discovery rulings, a request for a jury trial, a denial of a 12B6 or summary judgment motion. Note, I said denial. What happens if the court grants a motion for summary judgment in its entirety?
Case ends.
What?
Well, the case ends if there's no.
And it enters judgment.
So then they're appealable.
Yeah, because the case is over, it was dismissed. Okay, so that's appealable. An order granting a new trial. That's not appealable in federal court. Okay, so if the court orders a new trial, you go to get a new trial and you go to trial, don't pass go. Different in California. That's an appealable order in California. Okay. Pretrial motions that are considered final for appeal include injunctions, if granted, certification of class actions pursuant to Rule 24F. Okay, we'll get to class actions later, but if a court certifies a class or fails to certify a class, that's appealable. And governmental immunity claims, in particular, civil rights cases. If if the governmental entity loses on its motion for summary judgment on a civil rights claim, they can they can take it up on an interlocutory appeal. And for more on that, read note 2A and B on page 695. The case is Nixon versus Fitzgerald and Mitchell versus Forsyth. Now remember that case that we talked about up in Amador County where they took up 2 appeals and cost me 4 years and provided me with nice attorney's fees. Okay? Did we ever talk about what that case went for? In attorney's fees? And what it settled for? Okay, so they filed motion for summary judgment. They lost. They took it up the first time. Then they came back, found some new grounds upon which to file motions for summary judgment. They lose on those, goes back up. So by the time we got done, I had set it up, even though I was only billing for $350 an hour and I had associates at, I think, $1.75 or something. Our attorney's fees over 7 years were $1,400,000. So as it got close to trial, they caved and they said, okay, we think it's time to mediate this case. Will you provide us with your attorney's fees? And I said, certainly. And I redacted them. You guys all know what redacting means now, right?
Yeah.
We've heard about redactions in the last few months like crazy. So all you do basically is you've seen attorney's fees, right? Anybody else seen attorney's fees invoices? Right? They're like computer sheets. And so you go through the attorney's fees and you redact anything that's attorney-client or work product. So basically all it says by the time you get done is it shows
Email or call or something.
yeah, email to
Right.
right regarding redacted, okay, and the amount of time and the dollar amount. That's all they need. I mean, it doesn't matter what it's about, okay? Or, motion for summary judgment, and then you go through it, but you don't put down any of the details about legal theories and stuff like that. So it was $1.4 million. So we go to mediation, and of course, they've hired an expert to testify or to provide a declaration that he thought that $1.4 million was too high. And in Sacramento, at the time, you may not remember this, but at the time this occurred, they had a standard for attorney's fees, and it was $250 an hour. But I put myself down at $350, and then I had associates of $175. I figured, number one, I could probably justify $350 because of my experience and how long I'd been practicing and my expertise in the field and yada, yada, yada. Okay. But if not, since you get the associates do a lot of the heavy lifting, the light lifting anyway, when you kind of average it out, it'd probably come out to $250 anyway. All right, because at that time my billing rate I think was $500 an hour, and I reduced it. So we go to this mediation, and we're in chambers with the judge, and they're going, they're pounding the table, and this is outrageous, and $1.4 million is ridiculous, And it should only be, I think they were saying 600,000 or something. And part of that was because my billing rate was 350 and the average is 250. The standard in Sacramento was 250. And first the judge said, well, the judges here have been talking about 250 is really kind of low. And we're thinking of changing it. So, Mr. Moyer, what's your average billing rate? And I said 500. And he said, yeah, you're down there from Beverly Hills and you came up here and you reduced your rate, right? And I said, yeah. And he said, I've looked at your CV. I think that's good. So you guys can forget about the 350. I mean, I think he should get it. So what does that get us to? And they, 900,000. And then there was this, and then there was that, and they shouldn't have, they took too much time on their motion for summary judgment. It was crap, okay? But this is what you do with attorney's fees claims. So I said, I'll tell you what, why don't you guys produce your attorney's fees? Because there's 4 different law firms. So we'll take a look at yours and see how you guys compare to mine. And all these guys are sitting there going, and the judge says, I think that's a great idea. What do you guys think? And they said, well, we need to go talk to our clients. And so they leave and they come back. He said, our clients won't allow us to do it. It's attorney-client privilege, blah, 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 blah. And the judge just kind of winks at me and he says, so what do you guys think it's worth now? And they said, okay, $1 million. And I said, and they leave and he says, $1 million, that's pretty good. You guys, you can sell this case for $1 million. Well, and I said, it's not enough. And he said, what? And I said, it's not enough. He said, why not? I said, it's not enough. And he said, okay. I had no basis for, it just didn't sound right. And I knew I could get more. I mean, it's just that simple. And so he kicks me out, calls him in, and it settled for $1,250,000. Okay. That's on the basis of attorney's fees. Okay. Why was it so much? Because of the interlocutory appeals. Why did I just tell you that story? Because I want you to remember, you can, on a civil rights case, the defendants can appeal a motion granting summary judgment, denying summary judgment. Okay? Will you remember that? $1,250,000. I think we probably bill about $250,000 per motion. They were pretty, those motions, the motions in civil rights cases on governmental immunity are really complicated. I still don't understand the law. And I have 2 published opinions on it. Okay. All right, now there's an exception. There's an exception to the final judgment rule. Okay, and that's called practical finality, or the Cohen doctrine. Not to be mistaken for Michael Cohen. The exception applies to a small class of prejudgment orders that finally determine claims of right separate from and collateral to rights asserted in the action, and that are too important to be denied review and too independent of the cause itself to require that the appellate consideration be deferred until the whole case is adjudicated. That's the rule of Cohen versus Beneficial Industrial Loan Corp., 337 U.S. 541, 1949, which can be found on page 546 of Laurel Lines versus Chesser. Daniel. So this case is about the Cohen docs.
Yeah.
Okay?
All right, so, Chasser and some other individuals were passengers aboard Laurel's cruise ship.
I think it's probably chasse, and probably French, but anyway.
Chassis.
Anyways, they were on Laurel's cruise ship when it was hijacked by terrorists. So they brought suit for wrongful death in the district court for the Southern District of New York against Laurel for the injuries sustained and wrongful death of a different passenger.
Well, it was for passenger Leon Klinghoffer, who was an American. This is a big deal. Before your time, I guess.
Yes.
But that hijacking, this Leon Klinghoffer, who was an American, was killed by the terrorists. And they murdered him.
Did they shoot him? Or?
Yeah, I think they executed him. I think he was the only Jew on board.
On a wheelchair?
Yeah, I mean, it was pretty aggravated. Anyway, go ahead.
So citing a forum selection clause printed on the back of the ticket, Laurel moved to dismiss, and the district court held that the ticket didn't give the passengers reasonable notice and denied the motion to dismiss. So Laurel attempted to appeal to the Court of Appeals for the Second Circuit, which dismissed the appeal on the ground that the district court's decision was interlocutory, did not fall within the exception for collateral final orders, and was therefore not appealable. So the issue I have is whether an interlocutory order of a United States District Court denying a defendant's motion to dismiss a damages action on the basis of a contractual form selection clause is immediately appealable under 28 USC section 1291 as a collateral final order.
That's pretty good. I had everything you've got except is a forum selection clause is the court's denying the defendant's motion to dismiss a final judgment. Answer?
The rule is Title 28 USC Section 1291 provides for appeal to the Court of Appeals only from final decisions of the district courts in the United States. For purposes of Section 1291, a final judgment is generally regarded as a decision by the district court that ends the litigation on the merits and leaves nothing for the court to do but execute the judgment. The court says that in order denying a motion to dismiss a civil action on the ground that a contractual forum selection clause requires that such suit be brought in another jurisdiction and is not a decision on the merits that ends litigation. So Section 1291 permits an appeal only if an order denying a motion to dismiss based upon a forum selection clause falls within the narrow exception to the normal application of the final judgment rule that has come to be known as the collateral order doctrine.
Or the Cohen doctrine.
Yeah. The court says that exception is for a small class of prejudgment orders that finally determine claims of rights separable from and collateral to rights asserted in the action, and that are too important to be denied review and too independent of the cause itself, to require that the appellate consideration be deferred until the whole case is adjudicated.
Perfect. You got anything else?
Let's see. Well, they talk about a three-pronged test.
Yeah. Yeah.
So the first prong is whether the order conclusively determines the disputable question. Second, whether it resolves an important issue completely separate from the merits of the action. And third, if it is effectively unreviewable on appeal from a final judgment.
Right.
The court says that the order here doesn't satisfy the third prong. Although Loro claimed that based on the forum selection clause on the ticket, it could only be sued in Naples, Italy. But they say that this argument is rejected as it's much like the right not to be sued at all, which is a decision unreviewable upon appeal because the party's already been sued. And the right to be sued only in a particular forum can be vindicated on appeal. So that's why it doesn't meet the third prong of the test.
Yeah, it says it must be effectively unreviewable on appeal from a final judgment, and this is reviewable on, if there's a final judgment against them, it's reviewable on that issue.
Correct.
So since it's reviewable, they said since it's reviewable, we don't have to deal with 1 and 2. I thought that was interesting.
Yeah.
I mean, I would have thought you had to satisfy, it says and 1, 2, and 3, but they turned it into, I guess, 4. The court goes on to say an order is effectively unreviewable only where the order at issue involves an asserted right, the legal and practical value of which would be destroyed if it were not vindicated before trial. What does that mean? This is what I got. I mean, I don't know if it really follows that or not. It says an order denying a defendant's motion to dismiss on the basis of a contractual forum selection clause is not a decision on the merits that ends the litigation. Right?
Right.
And it goes on, it says, on the contrary, such an order ensures the litigation will continue in the district court.
Yeah.
Whatever that means. So basically what it's saying is, if the order it doesn't make sense. I can't resolve what it's saying, other than you gotta remember that the 3 prongs, okay, and if it's not on the merits and it will continue the litigation, then they're not going to find that exception. Look at their note 3. Let's on page 696. And this is a list of orders to be found to be final pursuant to the Cohen Doctrine. And it says it's an incomplete list, but it includes orders declining to apply in federal court a state statute requiring the posting of a bond in a shareholder derivative action brought by plaintiffs, owning a small amount of stock. That was called. Orders vacating the attachment of a vessel. That's definitely one to watch for. I'm not serious. Orders denying a party leave to proceed in pro per. You know what that means?
Proper?
Huh? You know what it means for a party to proceed in pro per?
They defend themselves.
Yeah. So, if somebody makes a motion to represent themselves in pro per and the court denies it, in federal court at least, it says here that that's considered to be practically final. So they can take that up on an interlocutory appeal, which means most judges grant motions to act in pro per, okay? Because they don't want to be appealed. Orders refusing to dismiss actions against government agencies on the ground of 11th Amendment immunity from suit. And orders remanding diversity actions on the grounds of abstention. You're not going to see that very often. 4, these are cases which have held the order in question not to be practically final. Orders referring to certified class actions. So if the court grants a certification of class actions, that means that the defense can take that up on an interlocutory appeal. But if the plaintiffs are refused their application to classify it as a class action, they can't appeal that until the end of the case. I mean, they can make that at the end of the case, they can appeal it, but not as an interlocutory appeal. Why? Because as you'll see in later chapter, the Supreme Court, the United States Supreme Court, at least the conservatives on the Supreme Court, don't like class actions. Okay? So defendants can appeal if class action is granted, but plaintiffs, if they're refused, can't on an interlocutory basis. Orders disqualifying or refusing to disqualify trial counsel for alleged conflicts of interest. No interlocutory appeal. Orders denying permission to intervene. Orders denying a motion to dismiss on grounds that a person is immune from service of process or nonconvenience. Orders requiring class action defendants to bear the costs of notifying members of the class. They can't appeal that. Orders rescinding a dismissal pursuant to settlement. You understand what that means? An order rescinding a dismissal? Right? The court decides it's not going to dismiss the case. Orders refusing to apply the judgment bar rule blocking a constitutional suit against the United States. Okay, Remember those. And read all the notes on pages 695 and 6095 through 697. Okay? If you haven't already. Of course you have, I know. All right, let's look at scope of review. Brian. Yep.
Anderson v. Bessemer City.
Anderson versus Bessemer City.
Okay. So the facts of the case, so the defendant sought a new recreation director, Bessemer City sought a new recreation director, and Ms. Anderson was the only woman to apply for the job. A 5-member committee interviewed the 8 applicants and chose a male, so Ms. Anderson sued alleging discrimination. So it was a 2-day trial during which the court heard testimony from petitioner, Ms. Bennett, and Mr. Kincaid, the successful applicant, and the 5 members of the selection committee. The court issued a brief memorandum of decision setting forth its finding that petitioner had been denied the position on account of sex. The court also requested that Anderson's counsel submit proposed findings of fact and conclusions of law, expanding on those set forth in the memorandum. And so the court finally found that Anderson was denied employment because of her sex, and so they rested their findings on these subsidiary findings. That Ms. Anderson had been better qualified than Mr. Kincaid, that male committee members had in fact been biased against Ms. Anderson because she was a woman. He said it's a finding based in part on testimony of one of the committee members that he believed it would have been read really hard for a woman to handle the job, and that he would not want his wife to have to perform its duties, and that Ms. Anderson alone among the applicants had been asked whether she realized the job would involve night work and travel, and whether her husband approved of her applying for the job. And
Whether
something
her
about that.
husband had approved of her applying for the job. That's a really relevant question.
And
This is called screwing the pooch. Go ahead.
there's 4 reasons of something about that. The reasons offered by the male committee members of the choice of Mr. Kincaid were pretextual.
You know what that means? What's a pretext?
Not very.
What's a pretext?
I'm not sure actually.
Anybody?
Half truth,
Pretext, huh?
half truth, that they're not really saying the truth.
It may not be truthful at all. Pretext is pretextual is saying that you're going to do something. Doing something on a pretext is saying you're going to do something, and the basis for you doing that is a fake excuse. That's pretext.
So it's a lie. Is it a lie? It's a lie.
So,
Well, it isn't true.
so how the comments.
Okay, you know, you get it? It's like, they say,
Like an excuse.
well, it's just what they have here, they were clearly biased, but they said that the reason for denying her was that other people were more qualified. No, that's not true, but that's what they said.
And so, based on what you said, on appeal, the 4th Circuit's reversed on the basis that 3 of the district court's findings were clearly erroneous. Of course, they said the findings of petitioner was most on reasons that the petitioner was the most qualified candidate. The finding that petitioner had been asked questions that the other applicants were spared.
Okay, wait a minute, what's the issue?
So, can a court of appeal set aside the findings of fact of a district court on the basis that they would have come to different findings?
Okay, now, what did Justice White, Justice White is who wrote the opinion.
Mhm.
What did he write was the rule And what's the rule of this case?
Okay. So I found a rule on page 703. Findings of fact shall not be set aside unless clearly erroneous, and due regard shall be given to the opportunity of the trial court to judge the credibility of the witness. Or
That's Rule 52A.
Good.
Yeah.
So the court stated that a finding is clearly erroneous when, although there is evidence to support it, the reviewing court on the entire evidence is left with a definite and firm conviction that a mistake has been committed. So
You get anything else?
from his what he said.
Yeah. On that.
Well, moving speaking further on that, what I just said is where there are two permissible views of the evidence, the fact finder's choice between them cannot be clearly erroneous.
That's right. That's it.
The jury's the
That's it. Yeah, where there are two permissible views of the evidence, the fact finder's choice between them cannot be clearly erroneous, period. Okay. Anything else?
Well, these are the Court of Appeals, they improperly conducted a de novo weighing of the evidence in record, so they use their own judgment, I guess.
Well, they just started, basically, they just threw out the finding of the district court, and you know what de novo means?
It's a total new trial, right?
Huh?
Completely new.
Yeah, basically, it's a new trial. The trial courts, appellate courts can't do that.
Yeah.
Okay, that's really good. You did really good. You got it, you nailed it. So it was reversed. All right, then we get to Trish. Yeah, turn your sound back on.
Okay, there we go.
Okay, now we get to 28 USC 2111.
21.
The harmless error rule. It forbids the reversal for errors or defects that do not affect the substantial rights of the parties. A court must, after concluding there was error, decide if the error was harmful to the appealing party's substantial rights. This is basically the same harmless error rule that we see in basketball or football. What am I talking about?
Penalties.
Huh?
Check on penalties.
Yeah. They don't call something where it doesn't hurt anybody. You know, I mean, like in football, what are they looking for? They're looking for, you know, are you targeting? Are you face masks? Even though you could say it doesn't hurt anybody, think about, you know, if somebody's holding, I mean, they're not physically hurt, but if you're holding somebody in football, then you're harming the other side's ability to get at your side's player, right?
Yeah.
Okay, so that's harm. Pass interference, same thing. That's harming the whoever is trying to receive the ball, and you're holding the guy, you're doing something to prevent him from catching the ball. Can't do that.
Not according to the refs in the Saints game. I had to.
Yeah, but I mean that's a good example of harmless error, right? I don't know what they were thinking, but it's good that the Rams got in, even though they lost. Okay, so just think harmless error, football, basketball, okay? And you want to tell us about Herndon versus Jayco?
Sure. This is, takes place in 2007. It's a 2007 case. Plaintiff is Glenn Harden, and he bought a new 2001 Jayco recreational vehicle. He returned it several times because it had various defects. When the repairs allegedly failed to fix when these repairs allegedly failed to fix the vehicle, the Harden sued Ford, which made the chassis and the motor, Jayco, which made the body, and Bridges, the dealer who sold the vehicle to Harden. A report by the defendant's employee, by Jayco's employee, concluded that only one minor common leak was in part made by the defendant and that this could be repaired for only $250. The plaintiff did not rebut this, but objected to admission as hearsay. Defendant's attorney offered to submit it as an admissible form, but the district court declined and considered it anyway. The district court granted summary judgment, and then the Sixth Circuit Court affirmed the judgment of the district court. And the issue that I have was that was the defendant's employee's report admissions a harmless error? And the rule that I had was that the court must disregard all errors and defects that do not affect any party's substantial rights. And that's on page 711, but 711 in my book.
What's the rule?
The rule is the court must disregard all errors and defects that do not affect any party's substantial rights.
How about, huh? Yeah.
Rule 56 from 61.
Yeah. Or an error may be considered harmless if it doesn't affect any party's substantial rights. Right?
Right.
So what about here? How does that apply to this case?
They held that the admission of the report was a harmless error.
Why? Why is it harmless?
Because it was such a small error.
What would happen? The report says something adverse to the party that's appealing, right?
Right.
Okay. And it's the opinion of an expert. And the objection here is to form. They didn't use the proper form for a report. Okay, it wasn't under penalty of perjury, et cetera, et cetera, et cetera. So what would happen if the court reversed on that basis and it went back to the trial court? What would happen? Realistic.
Well, I think it's just too small. It's too small. It's not enough money to go back to court.
No.
No.
The moving party would correct the form of the report, but the substance of the report would remain the same. And the court would grant the motion all over again, and it would have been a colossal waste of time.
Okay.
Because the moving party, that is the appealing party, isn't harmed by the fact that the form is wrong. Okay? They were harmed by the content of the report, not the fact that it didn't say it was under penalty of perjury and it wasn't signed appropriately or dated or whatever it was. Okay? They're appealing on a technicality that doesn't get to the merits. Okay, so the court says here, although the admission of an expert report was erroneous because it wasn't in affidavit form, so there was an error, it was harmless error because the defendant would have been able to put the report in affidavit form and the result would have been the same. quote, notably, sending this case back to the district court will simply result in the affidavit being resubmitted in admissible form and the district court granting summary judgment again. The court concludes the court could not find that the district court's error affected Hardin's substantial rights, and most certainly, Hardin was not prejudiced by the error. Okay, so everybody got down harmless error?
Yeah.
Okay. Now you know everything you need to know about appeal. That's it. Hey, I'm 15 minutes late, we still got done at 17. Okay, now, between now and the midterm, it gets hairy.
Don't say that.
Huh?
Don't say that. So,
Well, now you're gonna be dealing with claim preclusion and issue preclusion, otherwise known as res judicata and a collateral estoppel. This stuff is not easy. Okay? And then we have the first half of class action, et cetera, et cetera. Okay, then we got the midterm, and then you go to California. I will send you a revised syllabus that has all the California stuff in it. So you can start, since you're all reading ahead, I'm sure you are reading ahead, right? So you can all start reading about California court.
That's your
Okay.
signature.
Sure. Did you sign it? Oh, I didn't sign it, did I?
Can you sign me in, Brian?
No,
I don't know your signature.
you weren't here.
What?
You were here.
Post videos and stuff
Yeah.
of like all these controversial
Gee, I
Yeah,
would
so
just see like
calls,
a
you know,
chat room for like
high school,
actually
college. Yeah, it'd be good, and you know, it'll all be like used in the push towards using more artificial intelligence. for some of the stuff, you know, so like
Okay.
outside, stuff like that, why can't that be
Here, would you give that to him? I need to look
you
ahead.
know? You know what I'm saying? There's
Okay,
certain
you guys.
rules where a robot can do better.
See you next week.
I think that makes part of.
See you later.
Yeah.
Okay. I'm just gonna do- What?
Yeah.
What? We're done.
It's the best day. All right. Hey, order some sushi.
It's our Valentine's Day present.
That's right, yeah, he must have a hot date.
Hey, man. I like
Happy
this.
Valentine's Day, you guys. We'll see you Saturday. And Saturday we're doing MBEs, right? Not essays?
Yeah. Thank God.
Okay. Wow. Woo.
See you later.
See you later. Have a good one. Drive safely.
Yep.
Woo.
You will.
No.
Yep. Am I loud?
He's gonna stay to do work or what?
What?
He's gonna stay to do work, or you're gonna, to do work?
We're done for the week.
Yeah, you did it?
Did what?
The homework next week?
No.
Oh.
I'm not doing that right now. You
Oh.
kidding?
Okay.
I'm exhausted. Dude, I've been at work since 7 this morning, bro.
That's crazy. Oh, I think you should do it, because.
No, I usually do what I hadn't finished for this week, you know, like when I was staying for, it was because I hadn't finished Civ Pro for this week.
Yeah.
Yeah. That's the only, I usually, it's usually just Saturday and Sunday for me, and then Monday night.
Yeah.
You know, I don't have enough motivation to stay right now and keep going on my real property or my Civ Pro, I can't do it.
Yeah.
So long week.
It's a long week. Well, you know, at least you don't have like MCO weeks. Those was my whole weekend. It was like, oh, I'm just so tired. I'm gonna leave.
Yeah, dude, it just gets frustrating when you feel like you're